I'm joined this afternoon with the Attorney General Michael Daly and the Minister for the Prevention of Domestic Violence, Jodie Harrison. And let me say, this was a terrible, terrible death, an alleged murder on a young mum in a town that's deeply traumatised as a result. The terrible scourge of domestic violence leaves a deep and lasting impact, and the death of these women, often at the hands of a family member, is escalating and of course horrifying to the people of New South Wales. To put it simply, there are serious questions for the New South Wales government to answer as to how this alleged offender was out on bail. We have a duty of care to alleged victims, particularly those that are awaiting justice through the criminal justice system. And the profound anger and loss felt by the family and friends of the alleged victim and the women's family and friends is completely justifiable, completely justifiable. I can inform you all that the government today, via the Attorney General, will be making a formal referral to the Crown Advocate David Kell SC, seeking urgent advice in relation to this matter for the government to determine whether urgent law reform is required in relation to bail laws in the state, particularly as they relate to domestic violence offences in New South Wales. That advice will of course look at the decisions made in April to determine what happened, the circumstances relating to it. Our obligation of course is to protect victims of crime in the state. As part of the government's decision making, we'll also be looking closely at the role of registrars when it comes to matters, bail application matters, particularly on the weekends, particularly in regional communities. The government wants to work with the magistrate, the Chief Magistrate, to explore the use of audio-visual links. These are weighty and important decisions for magistrates to make in obviously short periods of time. We want to make sure that those of the members of the judiciary, wherever possible, are the ones making those decisions and bearing the responsibility, of course, of those decisions. Now, we're prepared to answer any questions that you have today with one extremely important caveat, both for us and for you as members of the media, and that is that the man is facing very serious criminal charges in the New South Wales courts, and our primary responsibility right now is for justice for the family of the woman involved. So we won't be commenting directly about the person involved, and of course that needs to happen in concurrence with our search for answers in relation to bail law reform and policy matters in the state. I'm sure you can appreciate that that's an important caveat to put on this media conference and commentary in particular on this issue in the days and weeks ahead. I'm going to hand over to the Attorney General.
Thank you, Premier. Can I just add my personal condolences to the family of Molly Ticehurst, in addition to those of the Premier and the government. This is an outcome that's gutted the state, frankly. We all feel this quite deeply, so I offer my heart goes out to her family and friends as well. The Premier has outlined how I'll be writing to the Crown Advocate this afternoon to look at legal aspects in relation to the circumstances that surrounded the granting of bail. But the other very important issue that I'll be talking to you about now, the other important referral will be to the Bail Act Monitoring Group. The Bail Act Monitoring Group is a panel convened, it was conceived in 2014, consisting of Department of Community and Justice, Police, Corrective Services, the Office of the DPP, Public Defender's Office, Aboriginal Legal Service, Legal Aid and the courts and other stakeholders from time to time to look at and report to government on the operation of the Bail Act, on its objectives, on how it's functioning effectively, and also that will complement the work of the Crown Advocate. So the Crown Advocate will look at legal aspects of the granting of the bail. The Bail Act Monitoring Group will look at the operational aspects. The Bail Act Monitoring Group's been used in recent years quite effectively by the former government. I think former Attorney General Speakman referred 8 bail decisions to that group in 2021. They made certain recommendations. So they will be the body that will look at the circumstances around the granting of bail in relation to this matter. I should also say I'll be inviting the Women's Safety Commissioner, Hannah Tonkin, to sit on the Bail Act monitoring group, at least for this referral, and possibly after discussions with her on a permanent basis. But given that this is an alleged domestic violence situation, it's only fair and appropriate that we add her expert voice to that group as well.
We're all here today because of a life being cut tragically short. Molly Ticehurst's life has tragically been cut short, and my thoughts go out to Molly's family, to her loved ones, and to the really tight-knit community of Forbes who are grieving right now. We know that Molly is not the only woman to have been allegedly murdered this year. She is one of 25 across Australia. And that 25 isn't just a number, this is 25 people who have been loved, who were loved, whose lives really mattered. And enough is enough. We know that legislative reform is not a silver bullet. We know that domestic violence doesn't exist in a vacuum. We know that it is often the consequence of an accumulation of moments that has experienced bad behaviour, where bad behaviour has gone unchallenged or unnoticed, where bad behaviour has been ignored or where it's been normalised. So that's why it's crucial that we as a government continue to invest in early intervention, in prevention, in education, and really importantly in housing, to provide a safe place for women when they need to leave a domestic violence situation. If you know of domestic violence or suspect that domestic abuse is occurring, I ask, please call it out. Importantly, report it to police as you would any other crime. Domestic violence is a crime, it should be reported to police. Support for people impacted by domestic violence is available through 1800-RESPECT, and of course, if you are at imminent danger of threat, you should call 000.
Thanks, Jody, and we're all happy to take questions. Yeah, we expect the KEL advice to be back by the end of May, so inside the month of May, hopefully inside the month. That's important for the government to analyse the circumstances relating to this decision, the legal tests that were applied in relation to the decision, and any prospective government reform that we might be pursuing. In relation to the Bail Act reform group that the Attorney General spoke about, they're an existing body. They routinely make advice to the New South Wales government. I'd have to come back to you as to when they're going to report back. But the administrative side of bail applications and the processing of them, particularly in regional New South Wales, particularly on the weekends, is as much of a structural or resourcing issue as it is in relation to law reform. So yeah, we need to give them a bit of time to report back to government, but the KEL advice hopefully within the month.
There's a call today for specialist domestic violence and family violence courts with specialist judicial officers and so on. There's been a trial of this in Southport, Queensland. The reports are pretty good for it. Are you at all attracted to that as an idea?
I wouldn't rule it out. I mean, obviously, as the Minister for the Prevention of Domestic Violence has just outlined, this is not a single event. We're not talking about an isolated alleged crime. There are, and has been reported in the last few days, many incidents of those who had previous offences or who were out on bail that went on to commit offences, and the New South Wales government needs to look at all types of reform to keep people, particularly vulnerable people, safe as they're awaiting justice. We've got a duty of care to those women, and we take that duty very seriously.
You said
It's one of the questions that we will be assessing. And can I just say, in relation to the system, I mean, the system's clearly let down Molly. We know enough in relation to these matters before the Kell advice is even returned to government. The status quo isn't working, and we need to be looking at change to keep vulnerable people safe, particularly as they're awaiting justice.
you said that these reviews will look into the administrative sides of granting bail. Speaking with Molly's family and friends, they've suggested that potentially while granting someone bail, they should look at ankle monitors for offenders who are restricted from going to certain areas, like in Molly's case, Forbes, and also looking at the victim's safety before that offender is released. So looking at whether her home is safe and what measures are in place there. Those two things, will they be looked at?
Well, can I just say the victim's safety and the security of the alleged victim is critically important and should always be taken into consideration when it comes to bail applications and decisions, whether they're by registrars, by judges, by magistrates in New South Wales. And they've got every right to ask that question in relation to this decision. I can completely understand their heartache and their anger, and their questions are guiding the government's questions in relation to this. We want to give them answers. We know that they're, at the moment, going through absolute hell. In relation to ankle monitoring, I have to be confident that any intervention in relation to the tracking of an alleged offender, there's enough resources in place so that if there's a breach of bail conditions, it can be immediately confronted by law enforcement. So, for example, if there's a non-association order or there is a provision or a restriction in the bail applied for or applied by the magistrate or the registrar, that if there's a breach by the ankle monitor, police can intervene. And there's some of the questions that we'll be asking in the next few days. That's a long way of saying we need to make sure that changes that we make will in fact work. Look, that's a very reasonable question. Now, this is a resource question, particularly for regional communities, and that is the availability of magistrates on weekends when it comes to serious bail application matters. You'd know during COVID, most bail applications across the state via audio-visual link to Parramatta for decisions that were made, is my understanding. Now, the amount of crime in the community was lower than it is today, so we can't use that as a template. But I have to say that it's really important when you've got decisions that need to be made in relation to bail for very serious offences, that it's undertaken wherever possible by a member of the judiciary. These are weighty decisions, and we're asking members of the court, registrars, maybe without any legal training, to make very serious decisions. So we're looking very closely at how it applies on weekends in regional New South Wales. And it may be the case that we can rely more heavily on audio-visual links back to Sydney so that alleged offenders can get in front of a magistrate for a decision.
Do you consider the introduction of psychiatric assessment?
Well, that certainly is something that we'll contemplate the decisions in relation to bail. I don't want to front-run any advice that we get from Kell or others, other than to repeat again, status quo isn't working, and we need to make sure that we keep those who are the victims of crime safe, particularly while they're awaiting justice.
Just on the counter-terrorism plans today, are you concerned about the presence of terrorism received cells in New South Wales?
Well, look, I think it's important that you all receive an operational briefing from New South Wales Police and the AFP. I was able to get a briefing from the New South Wales Police Commissioner before attending this media conference, but obviously some of the information they'll release publicly, I need to let them make those decisions before I do, and that's for operational tactical reasons, but you'd all appreciate that.
Let's ask you about Angela.
Well, that's certainly what we're looking at. Not necessarily the exact transference of the legislation in relation to potential terrorism offences, but certainly a look at bail laws in the state to keep victims safe. And I can understand why advocates, particularly those that have worked in this space for decades on behalf of domestic violence victims, want change, want legal change, want cultural change in the state. They want even bureaucratic fixes that can ensure that we keep people wherever possible safe. I can, of course, give them this guarantee. We're looking at all of that. We acknowledge that the status quo isn't working for many, particularly young women, and we've all got an obligation to fix a system that isn't working.
Advocates are bound by legislation when they are deciding bail. Do you concede that the bail laws need to be strengthened?
We're looking really closely at that. That's part of the reason why David KLSC is giving advice to the New South Wales government, so that we can look at the information from a legal expert in the criminal division, and that any reform that we bring into effect in New South Wales will make a difference. Now, the government's track record is to seek advice from stakeholders, from victims groups, to understand what the ramifications of the changes are, to ensure that any change that we pursue will in fact work. We did that in relation to bail law reform changes for young offenders. We did it for post and boast laws in the state. We did it for strangulation offences for high risk offenders in New South Wales, all the way down to doubling the maximum penalty for knife offences in New South Wales. So we'll collect the information, we'll make a considered decision, but I am saying right now that the system obviously failed Molly and the status quo is not going to work.
For the Attorney General,
Just not going to comment on that right now.
for the Attorney, if I can you run us through the tests that have to be met for bail? And has anyone spoken to this registrar to ascertain whether they believe, in this case, those tests were met, or essentially what they were thinking?
That's what the advice that we will be seeking will be looking into. The tests that he's required to look at is in the Bail Act. There's a show cause offence. This was not a show cause crime. And then there's an unacceptable risk test. So the magistrate or the bail decision maker has to look at the facts and circumstances that they have in front of them and work out whether there's an unacceptable risk that the offender will recommit a crime if they are released on bail, interfere with the victim, interfere with witnesses, those sorts of exhaustive tests. That's the test that a bail decision maker, whether it's police, registrar or magistrate, that's the mental test, the legal test that they have to go through in determining whether to grant bail or not.
There are four elements to the test. First one's flightless, then the rest go down to the ones you just mentioned.
Yep.
Surely on the face of it, to anyone with even a glance at this, there was a clear risk on three of the four measures that this was not a viable case for that.
The Premier commented at the outset of this interview, Hugh, that we have to be very careful about what we say in relation to this matter, so as to not prejudice the criminal proceedings that are now on foot. The last
This
thing,
is about the bail questions
and
not.
I've received advice that even going into a discussion that you're inviting me to go into now could prejudice the criminal proceedings, and that is the last thing I want to do. I want to see justice done here for Molly, and I don't want to be the one who presents any risk to that happening.
Can I go slightly different way then? Have you spoken to the Chief Magistrate about this case, and are you satisfied that the registrars as well as the magistrates are getting the training to deal with
The registrars are legally trained. They're not judicial officers, but they do have power under the Bail Act to make bail decisions. The reason we are referring this matter off to the Bail Act Monitoring Group is so that they can look at all of the circumstances around the granting of bail. They're the ones who will provide expert advice to the government, and I don't want to preempt what they might say or do.
Just also with that bail monitoring, can I just clarify this is going to be front of there?
I'm going to write to the chair of the Bail Act Monitoring Group with some terms of reference and send them a referral in respect of the circumstances around the granting of bail and what avenues of reform might be available to government if we seek to go down that path in the future. I'll get back to you on that. I don't know what the answer is to that question.
The granting of bail usually focuses on the offender, whether they're at risk, what we've sort of just discussed there. Will you be putting it to them that the safety of the victim should also be looked at, including looking at their home and what services they've been put in touch with before the offender is released? At the moment it focuses on the offender. Will you ask for a focus to be put on the victim?
I'm not sure what you mean by the second half of the question about resources that might be applied to them. The Bail Act doesn't do that. If there's a government policy to, in due course, to provide victims or alleged victims with other resources, that will be a decision for the government, but it won't sit within the Bail Act.
But whether the offender is at risk of harming the victim and whether the victim is safe goes hand in hand. What I'm saying at the moment, when they're granting bail, they're looking at the offender, whether they are at risk. Should they not?
No, they are looking. You know, it's the same consideration. You can't have one without the other. You have to. The unacceptable risk test in the Bail Act mentions the victim and witnesses and people like that. So those considerations are already met in the Act now. They're supposed to look at those sorts of things.
But should we not shift the focus to have a look at the victim? I've been in court when they've granted bail to offenders. They look at what the offender, what their situation is, where they're going to be. They can put an ADO in place to stop them from getting close to the victim.
And they
at the moment, there's no consideration for whether the victim has means, whether the victim has a safe place to go, whether their home is safe, that type of thing. Should there not be a service that can be engaged? This is obviously not something that is within the existing Act. I'm saying looking at it with a fresh focus.
Well, these are the sorts of questions that we'll be looking at in the weeks and months ahead.
Yeah, look, obviously in relation to these matters, we want David Kell to look at the circumstances, to see what legal tests were applied and report back to government. And I'm not proposing to go through all of the elements in relation to that, but we will provide as much information as we can, short of jeopardising, we'll obviously have to seek legal advice, but short of jeopardising the ongoing criminal investigation to the public to see so that the community can be aware of what happened here. Thanks, everybody.